Good morning. Today we are going to see together the sources of international investment law as well as its historic and some general principles. The sources of international investment law are not any different from the sources of public international law as they are listed in Article 38 of the ICJ statute. You have customary international law, treaties, general principles of law, and finally, as a subsidiary mean of elucidation, jurisprudence and doctrine. Historically, before the second half of the 20th century, customary international law was the main source of international investment law. There was, in the 19th century and the first half of the 20th century, a international minimum standard of treatment, which were supposed to grant to foreign investors. So, for instance, there was a broad agreement on certain basic principles, such as the fact that a state had to compensate a foreign investor upon expropriation. This minimum standard of treatment relied on the institute of diplomatic protection as a means of enforcement. Diplomatic protection is the espousal by the state of nationality of the investor of the claim of that investor. In other words, once an investor exhausts local remedies and he has problems with the state hosting its investment, it can petition his own state to pick up his claim to the international level and pursue it against the host state either through a negotiation or litigation. Before 1945 and the conclusion of the UN Charter, diplomatic protection could even degenerate into warfare. For instance, in 1902, UK, Germany and Italy blockaded the coast and harbors of Venezuela as well as bombing them in order to force Venezuela to compensate foreign investors who had been affected by the Venezuelan civil wars. So you have here a customary system that relies entirely on the customary mechanism of diplomatic protection in order to enforce. This system, however, came under increasing strain during the second half of the 20th century. This for two reasons. The first is related to decolonization. The end of the old colonial empires and the Europe-centric international system saw the emergence of new Asian and African states, which wanted to be free to pursue their own economic development independently from their old colonial masters. For that purpose, these states wanted to be able to nationalize foreign investment without having to be concerned about international legal rules. So, during the 1960s and the 1970s, developing states tried to establish a new international economic order by using their majority in the UN General Assembly to pass a series of resolutions which declared that developing states were free to nationalize foreign investment and to decide the level of compensation under their own national law. They hoped in this way to modify international custom, which, as you know, is made up by the elements of state practice and opinio juris. So this was the first problem. The rules were less and less clear and there stopped to be the consensus underlying the international minimum standard of treatment. The second problem was related to diplomatic protection itself. Diplomatic protection is a very contentious and political mean of enforcement which can create tensions between states. So states became hesitant to use diplomatic protection because by pursuing a claim of an investor at the international level, a state could make for itself a new enemy. What was the solution for these two problems? The solution adopted by Western states was to write down the law in new treaties, as well as seeking new means of enforcement. The first bilateral investment treaty was concluded in 1959, and it was between Germany and Pakistan. Today, as we said last time, we have approximately 3,000 BITs, standing for Bilateral Investment Treaty. In all these treaties, the state parties abandon part of their sovereignty in exchange for the expectation to receive more foreign investment. They do it in two ways. Firstly, they agree on written rules that go beyond international custom. In this way, states recognize that international law is relevant for the treatment of investors. Secondly, the parties to these investment treaties delegate to international arbitral tribunals the power to settle disputes under international law. Now, it is we wonder that developing states, which in a multilateral forums like the UN wanted to change international investment law, agreed to confirm the status quo in bilateral negotiations. But the point is that developing states, which were strong together at the multilateral level, were very weak in bilateral negotiations, as they needed investment and very frequently did not have the international lawyers or the competence to negotiate these treaties and understand what they effectively contained. So all investment treaties have a similar structure. Of course, there are certain differences in the wording of individual clauses and in the formulation, but all of them contain clauses defining covered investment and investors, clauses on fair and equitable treatment, on expropriation, and finally, clauses on the settlement of disputes. Regarding the settlement of disputes, in 1965, the members of the World Bank negotiated a very important instrument, the International Convention on the Settlement of Investment Disputes, also known as ICSID. ICSID does not provide for substantive rules of international investment law. It only provides for a forum, for a venue of dispute settlement through international arbitration. This works in the following manner. Two states will conclude a bilateral investment treaty, and when drafting their dispute settlement clauses, consent to the jurisdiction of an ICSID arbitral tribunal under the rules of ICSID. In this way, there is a sort of complementarity. Bilateral investment treaties provide for the substantive rules, while the ICSID Convention provides for the procedural the remedy to enforce these rules. You will have noticed that I'm talking mainly about bilateral investment treaties. Of course, there exist some multilateral treaties. These were concluded mainly in the 1990s, and there are multilateral trade treaties which include investment chapters. Among them, the most famous are NAFTA and the Energy Charter Treaty. There were attempts in the 1990s to conclude a multilateral investment agreement, which would have done what the WTO agreement did for trade. However, these attempts failed. Consequently, and this is a big problem of international arbitration, you have a jigsaw, a mosaic of different legal regimes, of different treaties, and dispute settlement through ad hoc decisions which often lack of consistency. This is precisely because there is not one unique treaty, there is not one unique means of dispute settlement, and there is not one unique tribunal. This renders international investment law a very uncertain and unpredictable area of international law. What I just told you is, of course, only a little introduction. To find out more and really learn about these issues, I strongly invite you to do the reading that you will find in the relevant section of Canvas. I thank you very much for your attention.